Chief Justice, I've graduated to the tablet.
I noticed that. I mean,
I thought I'd tell you that since you told me in open court.
that's excellent.
If your lordship has volume 5A, page 552, your lordship may have it. This is TMA by my lord.
Volume
5A 552. This is a cases description, my lord. Writ petitions 300 just after cause title. Writ petition 5457 in the first line, my lord.
Yes.
This is that petition of 81. And this was before 11 judges, honorable 11 judges, my lord. And thereafter, if your lordship comes to page 779, same judgment, my lord.
What was the issue raised by you in that?
My lord, basically the similar issue which related to right to administer. This was the issue in Basha also.
Yes.
And the same issue was here. And my lord, one thing I just want to place before your lordship. When I came in 1981, there were at least 9 judgments to say that you can administer. Regulatory controls, all right. 9 out of 9 judgments, my lord, 1 9 judges, which is Xavier, 1 7 judges, Kerala Education, 2 6 judges, 4 5 judges.
Just tell us, come again. How many?
My lord, total 9 judgments, my lord, till 1975, from 57 to 1975. Kerala Education, my lord, first. 7 judges. Siddharth by 6 judges. In between, this Aziz Basha, my lord, honorable 5 judges. Father Proust, my lord, 5 judges. Right Petro, 5 judges.
Reverend Patro, right?
My lord. This is 69. 1969. Mother Provincial, my lord, honorable 6 judges, 1970. (1971), my lord, DAV, honorable 5 judges. (1974), my lord, Ahmedabad Xavier's, honorable 9 judges. And then comes, my lord, Gandhi Faiziam, 3 judges, 1975. I had gone to the Allahabad High Court because I had problem in administering it.
So just to go back, Father Proust is which year?
Father Proust is, my lord, which year? I'll just.
Since you have given us
Father Proust is 1968, my lord, 13th of September.
right, Basha?
Pasha is October 1967.
All right. Siddharth Bhai?
My lord, Siddharth Bhai is 63, 30th of August 1962.
And Kerala Education?
Kerala Education, my lord, 25th of May 1958.
All right. We got the... Yes.
So this institution, my lord, was formed in 1938 Admittedly, Muslims, members of Muslim community had given land, etc., and nucleus fund. 1940, it was registered as society. After registration, out of 40 members, 10 members were taken with permission of minority community from non-minority community. So Mr. Sibbal and Dr. Dhawan have both argued on this that you can have other members also. So I'm not getting into that. That became the reason to stop me from administering my institution. I went to Allahabad High Court. Allahabad High Court granted a stay. Immediately it was revoked in 1980, and then I had to approach this honorable court, and this question was framed by Justice Fazal Ali.
The actual sequence once again, just so that.
My lord, 1938, this society was formed informally. In 1940, society was registered under Societies Registration Act. I was extended with aid in the pre-constitution time. 1950 Constitution of India came into effect.
When was aid granted?
My lord, between 1940 to 50, I don't have exact date, my lord.
All right.
And thereafter, it was treated all along as minority institution till 1970. In 1971, my lord, 77, the administration stated in one line that it is not possible to recognize you as minority institution. One line. 1977, my lord, 13/1/1977. Again, 3/5/1978, I was told that we will not declare you minority, though it was being treated as minority.
What was the date in 77, you said?
13 of January 1977.
Yeah. Then repeated on?
3rd of May 1978.
Yes.
And 2nd of May 1980, finally, they said that your governing body is not limited to the scholars of Muslim minority. That's why I will not treat you as minority. Out of 11 members of governing body, I am told one was from non-minority or two. And that was the background, my lord. And till 70, my lord, till 80, when this last order was passed, I have already placed before your lordship, 9 judgments were there. What is the meaning of administration? What is the meaning of minority? And what is the background of Article 30? So in a way, my lord, 1940 society registration is like MAO of AMU before 1920. MAO was also a society. So that is the background in which, when this entire argument took place, this was referred to, not like the submission that I see, that was all unrelated issue and somebody just wanted to refer it, and this is how the impression has been sought to be created in the written submission of Union of India, my lord. So that is the background. Now I am coming to, my lord, educational institution, my lord. I have created a table, my lord. I have created a 1E, my lord, if your lordship has. Just to run through fast, my lord.
Table at
One is before I go to table, my lord. Then, your lordship, I have shown TMA Pi and TMA Pi 779, my lord, volume 5A.
You are showing us something at 779, I think.
779, my lord.
What is that?
It is the question which was left open to be decided by the regular bench. 779, my lord. Question 3. Your lordship has it. This question need to be answered by not to be answered by this bench. It will be dealt with by regular bench. 779, volume 5A. Dr. Dhawan has argued this indicia question in DMA 5.
Whether it was conjunctive or disjunctive or.
So now my petition was finally disposed of without going into this question 3A, volume 1E, my lord, page 73. Volume 1E, my lord. Page 73.
1A, right?
1E. E for
1E.
When it came before Honorable 2 judges, my lord, at page 74, my lord, this is the same petition, 5457. Writ petition 5457, 1981. I read, my lord, page 74. The petition above mentioned, along with other connected matters, being called for hearing before this court on 11th March 2003, upon pursuing the record of hearing counsel appearing for the parties, this court passes following order. The matters are covered by decision of Constitution Bench in writ petition TMA Pi and connected batch decided on 3rd of October 2002. All statutory enactments, orders, schemes, regulation will have to be brought in conformity with the decision of the Constitution Bench of this court in TMA Pi case decided on 31/10/2002, and as and when the problem arises, the same can be dealt with an appropriate forum and in appropriate proceeding, and the matter is over, my lord. So this is how my matter got closed. It's another thing that there are many petitions. Even today, Anjuman Rahmania has ad hoc principle for last 10 years, my lord, and it is working out of 53 sanctioned teachers' strength. They are working on 23. And 1,800 students. So that's that's another issue. So these statutory modifications have not taken place till now. Rather, there are different statutory provisions which have come taking away the right.
Right.
So what is the effect? What is the effect of this order then?
The effect of the order, my lord, in my view, would be that whatever TMA Pi's ratio is, as per that ratio, all the regulations, all the rules relating to appointment, administration will have to be brought in conformity with the ratio. So that is that's what I can understand. But what is happening on the ground is altogether different. There are regulations saying that you will not appoint, private agencies will appoint. This is what has happened in Anjuman Rahmania's case. They have been, the entire right has been given to private agency that they will prepare a merit list, and from that merit list, you will have right to choose. So these things are going on. This, with my respectful submission, my lord, this is not in conformity with this order, and that is the ground for me approaching this on. 780. this, my lord. Coming to the second point, my lord, because this was an issue which was raised by the other side. That's why I thought appropriate to address, my lord, on this. I'll just conclude it quickly, my lord. Educational institution, my lord, of their choice. My lord, it is a very wide term which relates to setting up of an institution. That's what Siddharth Bhai has said. But setting up is important, my lord. Page 113, volume 5A. Setting up, with my respectful submission, can be related to the historical facts which has already been argued by Dr. Dhawan. How it was set it up in TMFI. So once you set up an institution, you exercise your choice. That could be a primary school, and that could be a university. Now, after 1950, my lord, it becomes a fundamental right. Once it becomes fundamental right, then the entire system is obliged to give effect to that right to choice. Maybe that I may have to, I may be interested in establishing medical college. Medical college is not a university. I'll go get myself registered under Societies Registration Act. Myself registering into Societies Registration Act will not be termed as establishing an institution. It will be only a compliance of a statute which is existing to promote excellence, which has been argued. So this word setting up to establishment, the word used in 1950, I think, my lord, that needs little bit explanation on this. My lord, chart 4, page 4, volume 1E, my lord. I'll just quickly run through. It's only one page, my lord.
The table?
A table, my lord.
Where is that?
1E, page 4. This is all taken from Aziz Basha. On the left-hand side, my lord, Aziz Basha says, educational institutions are of very wide import and would include university also.
He is not opening.
Yes, sir. My lord, 1E.
One is both for brother Suryakant and me is not opening. We've got it displayed now.
Share it. I'll share it.
Yeah, yeah, thank you. Good.
It's also on the
Thank you. Now
screen.
we've got it on the screen. You can just tell us, yeah, education.
Page 4, my lord. This is both sides is Aziz Basha, my lord. I have given pagination. I'll not go there just to save time, my lord. Educational institutions are of very wide import and would include a university also. That's what Aziz Basha says. Now, right-hand side, my lord. Before Constitution came into force, most universities were established by legislation. So it's all right. Not disputed, I am on the left-hand side, not disputed by the Union of India, and hence it may be accepted that a religious minority had right to establish a university under Article 31. So in Basha also, the stand is that, yes, you can do that. Then third, my lord, it is true that the nucleus of Aligarh Muslim University was the MAO college. And on the other side, my lord, if your lordship sees, conversion of that college into university was not, however, by Muslim minority. What was this conversion? Conversion was legislation. It took place by virtue of central legislation. Now I will come left side, my lord, once again. It may be that 1920 Act was passed as a result of efforts by Muslim minority. Right hand side, but that does not mean that the ALIGARH Muslim University, when it came into being under 1920 Act, was established by Muslim minority. Them in the matter, but if they had brought into existence a university on their own, the degrees of that universities were not bound to be recognized by the government. That is the genesis, my lord. The entire thing falls back to recognition. In 1920, in 1950, Article 30, terminology is used, established. So that recognition becomes established. That's the interplay. How this was argued, my lord, this is also interesting. In Aziz Basha, when the matter came before your lordship, it was only in relation to administer. It is the Union of India that took a stand that, sorry, this university is not established. So the entire debate went in the line of established. Your lordship may have this for a moment, my lord, 3A. I just want to show that, my lord. 3A, my lord, page 7, my lord. 3A, page 7. This was not an issue of whether established or not established when Aziz Basha came here. 3A, my lord, page 7, my lord. May I read the last para? The petitions have been opposed on behalf of Union of India. And the main contention is that ALIGARH Muslim University was established in 1920. So this is what they said. And establishment was not by Muslim minority, but the government of India by virtue of a statute, namely 1920 Act, and therefore the Muslim minority could not claim fundamental right to administer ALIGARH Muslim University under Article 30. So this came during the argument from Union of India. Now this will become more clear, my lord, if your lordship comes to page 16, my lord. Item E16. In the middle, my lord, this is a small para of 5 lines. Page 16. The contention of the petitioner is that by these drastic amendment of 1965, Muslim minority was deprived of the right to administer ALIGARH Muslim University, and this deprivation was violation of Article 30. So the issue was this, Placetum E. But Union of India says that, so that's why it becomes, entire debate becomes established. So I'm coming back to, my lord, that volume 1E, my lord, table 6, my lord. Page 4 of that volume 1E, that table Roman 6 on the left hand side. There was nothing in 1920 to prevent Muslim minority, if it so chose to establish a university. It did so. If it did so, the degree of such a university was not bound to be recognized by the government. It could not insist that the degree granted by the university should be recognized by the government. Now on the right hand side, my lord, by Act of 1920, degrees were recognized by the government. Hence, an institution was brought into existence which could not be brought into existence by private individual. Then, my lord, 1920 Act is circumstance to show that the university came to be established in 1920 and not by Muslim community. Such recognition dependent upon the will of the government, generally expressed through a statute. This narration is for pre-independence time. Now, Article 30 is altogether in different shape, my lord. It is part of part 3. It's in part 3, where right to establish and administer is held to be absolute. Later on explained that regulatory things will apply, regulatory mechanism will apply. So that is the position post independence. There are 3 judgments at least to say that pre-independence, post independence doesn't matter. You will interpret fundamental right to give effect to and for the beneficial interest of the citizens. So I'm not going into that, my lord. Now, coming to the third point, my lord, recognition issue. Because Pasha says such recognition dependent upon the will of the government generally expressed through a statute. So the entire issue is recognition. About recognition, my lord, your lordship may have 5A76, page 76. Page 76. My lord. In between, my lord, in the middle of the page, my lord, from bottom, it's about 15-20 lines, my lord. Without recognition, lordships have got. Without recognition, therefore, the educational institutions established or to be established by minority communities cannot fulfill the real object of their choice, and the right under Article 30 cannot be effectively exercised. The right to establish educational institution of their choice, therefore, mean the right to establish real institutions which will effectively serve the need of their community and the scholars who resort to their educational institutions. There is no doubt, no such thing as fundamental right to recognition by the state, except upon terms that entail to surrender to the Constitution. Yes. Now, your lordship, this Kerala education, my lord, has been, your lordship may have 103, just to complete this, 103 in volume 5A itself. This is Siddharth Bhai, my lord.
Mr. Shamshad, can a minority institution say, I have a choice to establish a primary school, a secondary school, a higher secondary school, an intermediate college, a professional degree college. It's my choice. No difficulty. Can say that choice, according to you and the submissions on this side, is recognized by Article 30. Educational institutions of their choice. So it's across the spectrum. My question is this: can an institution say that when I establish, say, a university, you must necessarily recognize my right to confer degrees to that university without the provisions of an enabling statute?
No.
That I think we'll all be on the same page.
There are regulatory provisions.
There are regulatory provisions. So
those regulatory.
I'll set up an engineering college, but my engineering college should be recognized for conferment of degrees independent of the AICTE Act. No.
No.
Or that I'll establish a medical college and it should be. So if I have to establish a medical college,
I will fulfill the requirements. I will have this much, this big building. I will have these many teachers. These are the curriculums which I will accept. And if I have done all these, then I am entitled to be recognized within the system and carry on with the medical education.
Now, when is the university set up for the first time? When is the university established for the first time?
University is established for the first time, my lord. These are, there could be, because we are discussing AMU Act 1920. So pre-independence position could be different.
Would it be correct to say that the university owes its existence only to the AMU Act of 1920? Because the 1920 Act, there is no university at all.
No, my lord. There is university. The university is the Basha accepts this. that I had right to establish university and it was there. But your degree will not be recognized within the system. So
But no, we are not on what your right was. Was there any university at all in existence pre-horse the 1920 Act? Or is it that the entire character of a university comes into being only under the 1920?
the requirement of recognition of that institution as university existed before 1920, I will say like this. And that is the requirement even today for even if you want to establish medical college, you should have all these things. And once you assert this with the concerned institution, they have only this much indulgence, interference that they will check it. They create a team and they go there, inspect whether it is there or not. If it is there, then you can't say you become general institution. It's minority institution. I have established it because I want to give some benefit to the community. It is not 100%, 50%. I'll give it to the community because they are lagging behind. So that way, my lord's question, a recognized university in the system could be one thing. An institution which has everything which entitles it to become a university could be another thing. My choice, I can carry on with this without being recognized within the system. But I want to be recognized. So I approach the institutions. I approach UGC today. I approached the legislature.
But there's another issue that today you cannot set up an institution for the conferment of degrees which are not recognized. You can't say that, look.
Yes.
Nobody can say that I will set up a university. You don't recognize my degrees. That the law doesn't permit. If you have to set up a university today, it has to be recognized within the fold of the governing group. Otherwise, what will happen is, there's a reason for it, that students will take admission to a university, they'll pay valuable fees, they'll spend 3 years or 4 years of their life, at the end of it, get a degree which has no value.
My lord, that aspect, Dr.
Nobody
is arguing Professor Yaspal's case.
Right. Nobody can even say that I will establish a university today and I take the consequence of non-recognition.
I did not.
I'm good enough, my students will still come to me. Nobody can say that today also.
Yes, my lord. That's why I said that I may have everything which entitles me to claim a recognized university. I may be running that institution. But the moment I have to have my relevance within the system with the degree, then I will go to the authority. The authority could be any statute.
So we got your point. I think the drift of the submission is that the conversion of the status of MAO college into a university under the AMU Act was for the purpose of ensuring that the degrees would be recognized under law. And therefore, the Muslim minority itself was the proponent of this move to convert this into for the passing of the legislation, because you wanted the benefit of the degrees being recognized. Therefore, the act is only for the purpose of recognition. And therefore, you must look at the antecedent historical circumstances.
And in that background, in the statute, my lord may have used the word established in the objectives, etc. That time, nobody knew what is going to be Article 30 in 1950.
Fair enough. That point.
And that too.
Mr. Chandrchud, should we close it at that?
Yes,
about 45.
One point, my lord. And Xavier's, my lord, just note down the pages. Volume 5A, 217, 243, 255.
Can you just say volume 5A, page?
217, Justice Reddy's opinion.
Yes.
243, Justice Khanna.
Yes.
255, Justice Matthew, and again 259, and 287, Justice Beg. They all have emphasized how recognition is important. That's why this is, my lord, 9 judges, my lord. So that's how I conclude this point, my lord. As far as the group rights are concerned, my lord, there are various beneficial rights given to scheduled caste, scheduled tribe. Just take out that chart. OBCs. By statute, we create rights for women, physically disabled persons, victims of crime, they all get different benefits as group in different educational institutions as part of affirmative action.
Similarly, minorities also have a group right, which is recognized by Article 2930.
And for that, my lord, Keshwananda Bharti, my lord, 1E. So, my lord, I have just made a chart of this.
Just give us the page and we'll be done.
That chart, my lord, volume 1E, my lord, page 5.
We'll have a look at it.
I have given an instance of about
basic proposition. I don't think you need to on that.
5 universities, which are tribal universities created in tribal areas for tribals. There is a university for OBCs and SCs. There is a university in Delhi by Delhi government for women. And all are state funded. Yes, I can understand in tribal universities, the other side may object, saying that the reservation is defined nationally, so that will apply. But in that 2006 Act, there is a provision that reservation can be increased. So that is very flexible. So once we can have these group universities,
why not for the minorities?
Why not to the minorities, my lord? And on this line, my lord, this Keshwananda Bharti 1E, page 78, my lord. Page 78. Page 78, 1E. This para 535A. This has given entire background how these minorities, this minorities' right was discussed, debated, committees was formed, and how it became so important. I will not read, my lord, it's a longish para, and it has said that is in the nature of basic feature. This is, yes. So, my lord, I just conclude, my lord, by saying that this, my lord, minority's choice, please don't make it exclusionary. Siddharth Bhai said that you will not interpret with a cutting down effect. My lord, Bhasha is a cutting down effect, which takes away para 8 of Siddharth Bhai says that you will not interpret with cutting down effect. And my lord, this 5A, page 87, Kerala Education also says that you will take into effect what is the impact of a particular interpretation. The impact is that admittedly an institution which was established by minority is being taken away. And what 50% only seats that one aspires to give it to their own community. That's the effect. Otherwise, what rule we are not following? Mr. Sibal has already addressed your lordship on this, that we follow everything. The effect is that certain seat can go there. That's the effect. And for that, your lordship, with greatest respect, your lordship will not give it cutting down effect. Your lordship, my lord Justice Sharma on that day asked Mr. Farasat, aid issue. Aid has become irrelevant after 2-3 judgments. I feel from the other side's argument also today that there is some undercurrent that aid is there, so I will take this.
That's well settled. You don't have to give up your minority status when you seek aid. Because today there's a recognition that without aid, no institution, minority, non-minority, can exist. Therefore, merely by seeking aid or being granted aid, you don't lose your right to claim your minority status. That's now very well settled.
So Kerala and TMA, my lord, 11 judges.
Thank you, Mr.
I am deeply obliged.
Thank you. Now we have got, I think, Mr. Mrinal Chakrabarti, Mr. Pulkit Agarwal, and Syed Mehdi Imam.
For information that these new icons.
We'll call upon the other side now, I think. Yes, we can call upon that side. Thank you. So, Mr. Attorney, you will start.
My apologies, sir, for not sharing my very brief note earlier, but I've shared it now. I am going to address the court a very narrow aspect of the matter. Picking up from the last threads about the competently established university, I would like to look at
Where is your note?
that
Where did you
dimension.
get it, Mr. Attorney?
No, I have received, I'm just reading the line.
All right, we have just got the notes, so they will.
In my understanding, it's not a case which is emanated from a deprivation of an Article 30 right. If somebody keen to establish an institution of their choice, and that came to be declined, and therefore we need to reopen Ashish Basha for the purpose of understanding, establish and administer. If that is not so, we're only looking at Ashish Basha, whether it is reading of Ashish Basha would have any future implication. It could have a future implication only if there has been deprivation in a current context. If that is not so, Ashish Basha is a standalone case. It doesn't have any future implication at all.
Should we read the note so that we'll have your?
May I just quickly read my note?
Yes, let's read
And
it.
then pick up some threads out of the note.
Sure.
The jurisprudence of Article 30, besides the minority feature, has looked at two other aspects of the provision, namely educational institution and choice regarding such educational institution. Having regard to the constitutional protection and guarantee underlying Article 30, Supreme Court has not read any limitations on the scope of the choice of educational institution. Thus, we find that educational institutions purporting to import secular education in all subjects have been read into the choice aspect of Article 30. It can be further stated that it cannot be the concern or authority of the state to inquire into how the choice of educational institutions facilitate or serve the interests and needs of a minority community. Protection, promotion, or preservation of identity of minority section is the philosophy underlying Article 30. However, Article 30 is an enabling provision as well. The further key to understanding Article 30 lies in exploring the right to establish and administer part of the provision. In order that the educational institution of a particular character or class, I mark that aspect of it, of a particular character or class could be established by any person, minority or otherwise. The first prerequisite would be the legal competence or authority to establish that class of institution. In the absence of a legal competence to establish a given class of institution, the question of availing all attendant rights and claims in relation to Article 30 cannot arise. Under the constitutional
Can we just
scheme,
repeat that?
the power or
Mr. Attorney, just go back to item 3. I didn't.
item,
Item 2 and two, last
yeah.
part of 2 and 3.
Can we
Paragraph
just, can we reread 2 just a little slowly?
Para 2?
Because I'm also, yeah.
however, Article 30 is an enabling provision as well. The further
What do you mean by enabling provision? What do you mean by enabling provision?
Are you when you say enabling, are you referring to the choice of the minority? Then
you have already dealt with it in Article 1, paragraph 1.
you see, it's not an enabling provision in the sense in which we conventionally call enabling.
The choice part of it is
Because
enabling.
enabling provision is like Article 15.
That's right.
Where, where you have the choice to make a provision. 30 is not enabling insofar as the state is concerned. It's an obligation on the state to recognize the choice.
Enable the minority. The choice part of it,
So long as
the
you
higher
say
dimension.
enabling provision in relation to conferring a choice on minorities, it's...
That's right. That's what I went to.
It can't be that I as a state can either decide to
I'm
grant or
talking
deny
about
you
the
that
state.
status.
I'm not talking, I'm
Right.
talking about a minority.
Therefore, the words as well is little, may not be appropriate, if I can use,
I've used
permitted to use that word.
Deliberately, in the sense that the choice part of it is available to every citizen.
Yes.
But the higher status is given to a minority. Therefore, I say it enables them to reach a level beyond the other common consideration. That's how you put it. So, paragraph 3. In the absence of a legal competence to establish a given class of institution,
Just read this.
the question is, so, can I go to paragraph
sorry.
4 and 5?
Can we go back to your second sentence of para 2?
Yes. In order that an educational institution of a particular character or a class could be established by any person, minority or otherwise, the first prerequisite would be the legal competence or authority to establish that class of institution. As we go further, I will give further explanations about it.
Go ahead.
Right. So then as I go to para 4. Under the constitutional scheme, the power, competence, right to establish educational institution can be located only under an authority granted by a competent legislation. For instance, entry 25 talks about education. Then entry 14 list 2 talks about agricultural education. Similarly, entry 64 talks about institutions of scientific, technical education and are treated as institutions of national importance.
There is list 1. Huh?
That's right. Then prior to the Constitution, schools, colleges, other teaching institutions were established by societies or trusts by reason of enabling authority granted under the Societies Registration Act 1860 or the trust law to act towards the promotion of literature, science, fine arts, and for the diffusion of useful knowledge. Educational institutions such as schools and colleges are tools and instrumentalities in the pursuit and promotion of such activities. In other words, the competent to establish educational institutions of the above class towards imparting knowledge on the above mentioned fields of study was made available under the said legislations. I'm talking about the competence. Now, paragraph 5. Prior to the Constitution, prior to the Constitution, there was no other legislation that conferred competence on any set of persons to establish a university as such. There was no legislation that conferred competence to establish universities. In the absence of a law conferring or granting competence to establish a defined class of institutions, namely a university, the question of establishing a university did not arise. The ALIGARH Muslim University is a product of a standalone legislation enacted by the then existing provincial legislature. The antecedent events, namely the establishment of Mohammedan Anglo-Oriental College, sought to be connected with the coming into being of the ALIGARH Muslim University, cannot be said to be any part of the competence to establish the university as such. The Mohammedan Anglo-Oriental College was set up by the Muslim community, deriving its competence granted under the enabling provisions of the Societies Registration Act. That legal competence to set up educational institutions such as a school or a college cannot be extended to legal competence to set up a university. In other words, the power to establish a given class of educational institution must be granted under a statute. Prior to the Constitution, there was no power or competence available under any legislation either to establish a university or to convert a school or a college into a university. Consequently, the community of persons who had set up the Mohammedan Anglo-Oriental College did not have the competence to establish a university, and ALIGARH Muslim University was not established by them in the above legal sense and understanding. Establishment of a college is different from establishing a university, and the one does not and did not merge into the other. Ashish Basha rightly understands this position and rightly did it hold. Since the university was not established by the Muslim minority, it did not have the right to administer it. Then, in order, therefore, that after the coming into force of the Constitution, a minority community can claim the protection of under Article 30, it must first have the legal competence to establish a particular class of institution. The Societies Registration Act, like the law relating to trust, continued to be part of an enabling legal framework, by reason of which schools and colleges can be established. There must therefore exist a similar enabling legislation that either enables or facilitates or grants competence to establish a university. The scheme of the University Grants Commission Act, to the extent it regulates all matters relating to universities, including deemed universities, is comparable to such an enabling law. In the absence of a competence or authority granted or conferred under a law to establish a university, no person, whether belonging to a minority community or otherwise, can establish a university. The words educational institutions of their choice cannot be construed by itself, conferring an authority to establish any class of institution, regardless of a legal competence to do so. The authority to establish a given class of institution must first precede and be traceable to and be located under an enabling statute. The choice aspect of educational institutions will then follow. within the scope of an enabling legal framework, which may confer the authority to establish institutions, the choice aspect will be unfettered and free. And this is the essence of Article 30. So neither prior to the Constitution nor under the Constitution, a minority community was clothed with the authority to establish a university. In this legal sense, no infirmity can be attributed to Ashish Basha. The unfettered freedom to establish educational institutions of their choice does not extend to the grant of exemption from the obligation to abide by other constitutional demands and requirements. For example, the obligation to honor provisions relating to reservations or matters relating to regulations or appointments of teaching and non-teaching staff, etc., and including general regulation relating to standards and quality of education. The choice aspect of institution does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions, which are themselves as important as the choice, as long as the state does not impinge on the choice and which the state cannot. Article 30 is intact. The claim raised that Ashish Basha has wrongly interpreted the words establish and administer is misconceived. The question is not only of disjunctive or conjunctive reading. The fundamental question is one of the competence or the authority to set up an university. That being so, there is no warrant or need for reconsidering Ashish Basha, as it has no application to any post-constitutional institution, including an university. Therefore follows that for the purpose of Article 30, educational institutions need not necessarily include an university, and such an educational institution is subject to relevant regulatory regime. For the argument, I'll just conclude by a few more. If you go back to the history of granting degrees in England, from 13th century onwards, Oxford, Cambridge, all those universities.
One accepts if one goes by the tenor of your arguments, therefore, if a legislation is today made that school can be only established by this method, by registration under this act, then the right under Article 30 will also not be there. Suppose tomorrow, like the UGC Act, we have another legislation which says that the schools will be only established if you register under this particular act. Then that right will be also under Article 30, fundamental right under Article 30 will be also diluted to that extent. That choice will be then diluted.
Therefore, the whole question of a choice will have to be seen within an overarching legal framework or a constitutional framework. Constitution provides for an overarching framework. So statutes come in and say that this is what you will do. These are the kind of educational institutions that set up. That's why we're talking about a character, a class of an institution. So we did not all those judgments prior to, for instance, even St. Stephen. The court did not go into the question, where is the legal competence to set up an institution? Does it flow from Article 30 by itself? Perhaps the answer would be no. Article 30 comes in at a point of time when the competence part of it is answered. If it is answered well, within the broader legal framework or constitutional framework, my choice is unfettered. But to convert
in the absence of an enabling legal framework, there is no choice within the meaning of Article 30.
No, therefore, Article 30 premise on the availability of a legal framework. Otherwise, it will be a vacuum. Article 30 envisages it because there's a history about setting up institutions, including universities.
Will it not make it then subservient to a statutory legislation?
No, that's why we were caught into a circular argument. We are trying to come out of that. The argument, therefore, is my choice itself confer an authority to determine what will be the nature of a class of an institution. So, but in the absence of a defining framework, a legal framework, the choice will remain very abstract. It will have no social relevance and importance. Therefore, you can work wherever you are. You must work within the broader enabling legal or a constitutional framework. And within that, what I want to do, whether I want to have institution A, B, C, or D, and that is my choice. And how that choice will enable me to, exist as a minority is not a concern of state at all. That is where the unfettered freedom comes.
Pre-constitution, AMU was set up under the 1920 Act. Post-constitution, are there any universities which today have the have recognition as minority institutions post-constitution?
No.
Something which is,
The whole idea of-
Just, sorry, interrupt.
Yes, I'm sorry.
Probably after the Minorities Education Act 2005 and 2010, it's possible. Because there
Let
is
us
a
look
specific-
into that law. Let us look into the law just briefly, and then probably that will answer some of the questions.
That is possible.
And that will probably also support what I'm trying to point out. I'm not saying even
But your argument, if accepted, will mean any university set up by a.
I'll just pick up two provisions of the act. Yours kindly, it is PDF. Was putting some very. Yeah, I'm sorry.
2005 and then subsequent amendment in 2010
Yes.
with regard to minority education. Then it is possible to set up because once you get the status from that
Your Lordship.
under the said act, then obviously you can get it. But that was pointed out by Mr. Sibbal during the course of argument.
I heard so,
But
yeah.
prior to that, prior to 2005, therefore it was, according to you, as far as university is concerned, there cannot be any minority university.
No, let me close my eyes to a statute like that. Suppose Parliament enacted a different law conferring an authority to set up universities on any citizen whatsoever. And then what about limitations on that power to set up a university? The story would have been different. So therefore, to say that Article 30 is a reservoir of a competence or a power to set up a university. We are not talking about Ashish Bhasha. We are not talking about a future implication of a deprivation of an educational institution. Therefore, if we stray beyond that, then there are some problems.
your argument, if it is stretched, will apply to every educational institution.
That's true.
That according to your argument, it wouldn't then only apply to university. That unless there is an enabling legal framework, you cannot set up any educational institution in India. If your argument is right.
Yes.
You can't set up even a primary school. Your argument will apply to a school as well.
That's true. That's what I'm saying. Before,
So according
we
to
have
them,
today a plethora of
the Article 30
legislation.
right- the Article 30 right is contingent on an enabling provision of legislation recognizing
There are,
that right in statutory terms.
let me say the enabling legislation may have two components. One, to enable, to set up number one, to regulate what you do. So the
Regulation, there's no difficulty.
many,
Regulation, there's no difficulty. Enabling regulation, which says that, look, you have to have so many teachers, you must have so much of reservation, you must pay your salary, teachers' salaries at a rate which is prescribed by the union government, that you will get aid only if you fulfill these conditions of infrastructure. There's no difficulty about that. Problem about your argument is because once you say that your right under Article 30 is contingent on an enabling legal framework, that will apply to every right, every matter of choice under Article 30.
That's right. But then to say because it will apply to every citizen, then how do we locate Article 30, the importance of Article 30? Then we need to depart from that regular framework and say have something special for Article 30. My answer would be no. Therefore, the competent to set up a particular class of an institution, what we are trying to talk about. We're not talking about a university in the abstract. Any class of an institution, you will have a legal competence because every attendant consequences will follow with a competent.
And does it make a difference whether the institution is set up by or under a statute?
I know it has created some
right, because by a statute you can possibly say, as in the case of AMU,
in Vice Degree College.
that it has been set up by this statute. What about a university or an institution? We forget the university issue. You set up an institution under a statute.
I'll just give you examples. There are some states which are called universities legislation. Karnataka, Kerala, they have this university legislation. Under that act, you can set up a university. Or there are private universities. I want to set up a university, but I can't do on my own volition. There are any number of private universities. The state legislature intervenes. So in the absence of an intervention by a legislature, even private universities cannot come up. Therefore, the competence part of it, either a legislature intervenes or a law intervenes and provides you and gives you that competence. It's very important. Therefore, prior to 1920 Act is where the legislature intervenes. I am setting up a university.
But does the fact that the legislature, you rightly gave the example of, say, legislation in the states, which has this standalone legislation providing for the establishment of a particular university in a state. Private universities have been established in Tamil Nadu, for instance.
Any number of private.
Any number of states. Haryana. So many universities have been established under deeming legislation of the state governments. Now, does the fact that the university has been established by legislation of the state by itself amount to a denial of the right to claim minority status?
No, in a given case, I
Does
said,
the fact that the university has been, institution has been set up under a law amount to a denial of its right to claim minority status?
right.
If the answer is in the negative, then when do you say that, well, your minority status cannot exist?
May I put it the question?
Suppose there is a society. Suppose there's a society which is established by a minority A, whether it's Zoroastrians, Jain,
Right.
whether it's linguistic or religious minority. That minority then seeks to set up a university. A law is enacted by the state legislature providing for recognition as a university, that the university is set up. Now, the institution itself, the foundation is by a minority. The society is a minority society. The state legislation confers upon it the character of a university. Does that by in itself amount to a denial of the minority status? Two, suppose there's state legislation which allows for the setting up of universities, right? And a particular minority seeks to set up an institution within the purview of that legislation.
My answer.
Would that by itself lead to the denial of minority status?
My answer to that, now that there is a law occupying that field, Minority Educational Institutions Act, so that will address all these questions. And even that, let's only look at two provisions of the Act, Section 10.
Let's see the Act. Where is it?
It is volume 4A, PDF, the Act begins at PDF page 221. At page 223, solicitor's note on this act is fairly exhaustive. He will deal with it. But just want to point out, say that 10 and 10A. 10 begins with this, subject to the provisions.
Mr. Solicitor, Mr. Attorney, is there any university established minority institution, university established after 1950 till 2010?
No.
50 to 2010? No. There's none.
They're all schools, colleges, deemed universities under the UGC.
After 2010, obviously, with the amendment made in the Act?
There are. Therefore, Section 10 talks about subject to the provisions contained in any other law for the time being in force. So this could be a law relating to regulation. This could be a law providing for certain requirements relating to establishment. It could be any law.
You're right, Jamshid. I was just saying with 2G.
It will show me that. No. Can it be just shared? some about this English position. It's a yes, I do.
The right under Article 30, in certain areas, as our law has evolved, may well be conditional or contingent upon provisions of a regulatory statute. For instance, the right under Article 30 to establish and administer institutions of your choice, when you seek recognition, that recognition is contingent on provisions of regulatory statutes. When you seek the award of degrees, that right would be contingent on your complying with provisions of regulatory statutes, which are intended to define what the course of study should be, what should be the length or duration of the courses. When you seek to get aid from the state, there would be regulatory statutes which would define what is the nature of staff that you are going to engage. Will you engage people who have basic minimum qualifications? If you're a law school, that your staff must have passed the net set examination, right? If you have to appoint a professor, that professor must have completed a doctoral degree. Years of experience for movement from, say, an assistant to an associate professor to professor, so on and so forth. Therefore, there can be no manner of doubt that the right under Article 30, the exercise of the right is contingent on compliance with regulatory provisions. Those regulatory provisions ensure that the true character of an institution as an institution of excellence, as our court has said repeatedly, is maintained. Second, that even minority institutions do not fall below a national standard in terms of the quality of the students which you admit. That they must all pass the CLAT exam for admission to law, or they must all pass the the NEET examination for admission to medicine, that they must pass the JEE for admission to the engineering degree courses. So regulatory statutes can define the minimum qualifications for the body of students, the staff, and the quality of the infrastructure which the institution must maintain in order to gain recognition. No difficulty. There is now the law has made that very, very clear. Minimum salaries, for instance, Frank Anthony Public School says that. But can the right to establish an institution itself be contingent on recognition by an enabling statute? That your argument seems to be overbroad.
I'm not saying recognition by
Because,
enabling.
because what you have said in para, the choice, para 9, the choice aspects of institutions does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions which are themselves as important as the choice. No difficulty. Regulatory provisions the state is entitled to make. I don't think any minority today can say that I am exempt from regulatory provisions. But can you say that, look, your right to establish yourself as a minority institution itself is contingent on enabling provisions in a law? Then you will be making a constitutional right subservient to a statute. The Constitution can do it. The Constitution can do it. We are not saying that the Constitution, if it has done it in a given case, that that provision is bad. But 30 doesn't do it.
I think I'm not trying to convey this proposition that recognition of setting up an institution is part of a regulatory and therefore it is subsumed within it. I don't propose to say that. What I'm saying is, before anybody can set up an institution, you must have some authority of law or a competence or a power available to you under some law. You can't say, I desire, therefore I set up.
Undoubtedly, for a moment we concede that point.
Right.
But your argument that before you set up an institution, there must be an authority of law. Even if you want to set up a primary school, there has to be an authority of law.
That's right.
Some law in Uttar Pradesh, Maharashtra, Tamil Nadu, where you are allowed to set up.
So we call
But
it.
does that by itself detract from your right to establish a minority institution within the framework of the law?
No,
Or
within
to put it differently,
Within the framework of the law, then the choice
Right.
is entirely there.
right. So, or is it your argument that once there is a law, the moment you establish the institution under the law, you lose your right to claim minority status?
No, that's not what I will follow from what I'm saying. But saying once you
Or
have
that
the authority,
or that your right to claim minority status would be contingent on the law recognizing your right to claim minority status.
I
That
don't
I'm not
think
sure
that will
with.
follow from my submission. I'm only trying to narrow down a proposition that before you set up any institution of a particular class of institution, where will you derive your competence and authority? If that competent authority is lacking, you can't say independent of that competence, I still have a right to establish.
Fair enough.
That's all what I'm trying to point out.
Right, fair
Therefore, Ashish Basha came prior to the Constitution. We don't have Article
But
30.
can the law say that because you do not have a right to establish an institution absent an enabling provision of law, and now I have an enabling provision of law, my enabling provision of law is contingent on your not claiming minority status? Can you do that? No. That will be violative of Article 30.
That's not what I tried to. No, I'm not saying. So it's therefore in the narrow context of Ashish Basha, I think this is what probably one would look at. And I was trying to point out in England, all those universities came by a charter,
थोड़ा सा ऊपर
degree,
जाइए।
award, just.
ऊपर नहीं, नीचे। थोड़ा सा नीचे।
So in a sense, therefore, even today, the University Grants Commission Act, it could have probably been a different legislation. It could have been a legislation conferring authority on any citizen, including minorities, to set up universities. But it did not do so. It is again enabling legislation. If you want to set up a university or to become a deemed university, you fall within this requirements in a regime. So this is, Volta universities operate under a royal charter. Some of these charters go back many centuries. The universities of Oxford and Cambridge received theirs in the 13th century. In Scotland, so and so granted theirs in the 15th. A number of new universities are created following the two acts of parliament. In the 1992 Act is Higher Education Act, is more or less corresponding to the UGC Act. And then further Higher Education Act authorized the Privy Council to specify providers of higher education as competent to award untaught and research degrees. Therefore, the question of degree, we are talking about that. So who can confer a degree? Why can't the person establishing a college confer a degree? For that part, again, there are certain competences available to do something in the field of education.
Right. You've got the point. Thank you, Mr. Chandrchud.
Right.
Thank you.
May I add something?
At the in rejoin the
Para 22, 92, even if regulations are invasive, they will fall violative of Article 30. For example, in St. Xavier's,
head of the institution, I'll give you a classical example. Our court has held that you have an unfettered right to appoint the head of the institution.
yes,
Right? No law can say that the head will be chosen by a panel consisting of, say, the vice chancellor, a professor nominated by the vice chancellor.
Right.
That is clearly violative of Article
even
30.
regulations cannot be invasive. Lily
That's what
Korean
I'm
says
saying.
you dismiss somebody, you can't say you require the permission of the vice chancellor.
So, for
Struck
instance,
down.
I'll give you an example. See Section 5, there's an act in Maharashtra called the Maharashtra Educational Institutions Conditions of Service Regulation Act. Section 5 says that the right to appoint a head and any any other two teachers is exclusively given to minority institutions. Because our court has said, head, you cannot say that I'll impose the head on you. There's an unfettered right to appoint the head. The vice chancellor can't say that I will, Vice Chancellor of a university which is, to which that institution is affiliated. Vice Chancellor cannot say that, well, I will constitute a committee to appoint your head. Our judgments have consistently held that head you have to appoint, because the head of the institution decides, that determines the character of the institution.
No, that's the point I was making.
Yeah.
Yes,
Mr.
Mr.
Solicitor.
College reference, you'll just make a note of that about by or under. It has an exhaustive,
Which one?
vice degree college.
Vice
The
degree.
1976 to.
Justice Bhagwati's judgment. No?
It is perhaps it
Yeah,
is.
Justice Bhagwati.
Which judgment? It is a vice degree college. Lakshmi Narayan was in the executive committee of vice degree college.
Vice, yes. Vice degree. It's there in our society.
Is that a compilation? Yes, like this.
Write down certain problems. Make them in basic.
It is vice degree.
That
Yes.
is vice degree, Bharat.
Vice degree.
It's there in our.
Yes, Mr. Solicitor General.
Perhaps attorney wanted to say.
Fully agree with Mr. Dhawan that if regulation is invasive, which denies right under Article 30, the regulation would be bad. There is no quarrel on that, but I am not taking your lordships to a different point of view.
Yes.
Lord, your lordships are examining the law laid down in Aziz Basha, where Aziz
Yes.
Basha, my lord, examines the law which is enacted by the Imperial Parliament 103 years from today. We are, my lord, traveling back to it's 2020, we are in 2024. Lord, Aziz Basha will have to be understood in the context of the historical background in which Act of 20 was passed and historical background in which Aziz Basha was decided. Because my respectful submission is, Aziz Basha does not lay down a law of any universal application, nor does it lay down any ratio which the petitioners have understood.
Yes.
But the petitioner's main argument was that Aziz Basha lays down that once you are established by an act of competent legislature, you can never become a minority institution. And the logic behind their submission is, and rightly so, if that is the ratio, but it is not, that now UGC Act requires that a university can be incorporated only by an act of parliament or competent legislature, and therefore there can be no minority institution, a minority university. That is not the ratio of Aziz Basha. there was a particular regime in place during which, my lord, this movement started of establishing universities. That is somewhere in or before 1920. There were educational institutions either recognized through an act of the imperial legislature or otherwise. There were several universities, several institutions which had no blessings, Lord, of the imperial legislature. Lord, there were simultaneous two streams which were going on. One was, and we may not forget, my lord, 20s were the years where the freedom struggle was at its peak. One stream was that no, we will have our own university and we will not depend upon the British government's legislative competence or legislative power. The nationalists, my lord, they are historically called the nationalists. Without meaning any disrespect to the other group, my lord, that's how they are, my lord, described. Second was that no, we must have an act of the imperial legislature so that the degrees are recognized where in the employment of crown, degrees of non-registered universities were also recognized, but not in the services of the British government. And not, of course, outside the country.
Yes.
So having more than one options and several, in fact, the majority, like my lord, Vishwabharati University, Shantiniketan. Shantiniketan was an institution. It had no blessings of the British government. It became university after UGC. And it was granting degrees and their degrees were valuable. IIT Roorkee was an institution without any imperial legislation. You had that option.
When was IIT Roorkee set up actually?
1857. The name was different, Thomson College of Engineering, but 1857. Thereafter, somewhere in 30s, it became IIT Roorkee, but remained unaffiliated. Lord, what I'll ultimately, Lord, I'll just say the end first and then take your lordships to the historical background. There were two simultaneous streams going on. I'm sorry. Lord, those who were in favor of, so far as this university is concerned, those who were in favor of accepting the conditions imposed by the British for the purpose of passing an act and making you an university. And the second, that no, we will continue with our minority Muslim status. We will not succumb to the British. We don't wish, because Britishers were saying that if you want a university status, you will have to give up some of your minority status. It would be a kind of neutral or a kind of a secular network which we will provide.
Not just minority status, but your cultural status as well. Your non-minority cultural status which you are claiming.
That I'll show. Those who were in favor of having a university called ALIGARH Muslim University under an act of imperial legislation, provided for that, and an act was passed where they surrendered many of their rights. And those who were confirmed, who were very sure that no, we will not, it would be an Islamic institution, they, in 1920, from the premises of ALIGARH Muslim University, declared Jamia Millia Islamia. Jamia means university in Urdu, Millia means national, and Islamia means Islamic. They continued their status as minority institution the way they wanted without surrendering anything, and they were registered after the UGC Act came into force. They were recognized. I'll take your lordship through that. Therefore, my lord, the ratio in Bhasha is that at a time where there were no fundamental rights, there was no Article 30, you had a choice of either not surrendering your rights or surrendering your rights and get an act of parliament, imperial parliament. You chose to surrender, and therefore it was established when it was passed by imperial legislation. And in 1920, there was no Article 30. So it was a voluntary surrender. Today, I cannot be asked to surrender my fundamental rights. But Britishers did, and they could. Everything is documented, and documents are on record from the beginning. What I have done, my lord, I was told my learned senior Mr. Singhvi's, Mr. Sibbal's objection that I have placed some new documents on record. They are, my lord, acts of constituting or incorporating several universities. I'm not going to read them, but I don't wish to be accused of suppressing something. My lord, the way they did, they placed on record, my lord, 3rd September 1965 debates without placing 2nd September. I have placed everything. I'm not going to read them. Now, please see, my lord, my note 2F. And, my lord, kindly examine Aziz Basha in this context, my lord. Note 2F, my lord, page 1. I'm sorry, volume 2F, page 1. This was the regime in place where 1920 Act was passed.
Just one minute.
Volume.
This is Roman 2.
My lord, Roman, sorry, my lord. Roman 2F. Lord, I'm sorry, my lord. I stand corrected. I should have
It's the last one.
said Roman.
One.
Will, my lord, with your lordship's permission, we'll change it to 2B1, my lord. I think it was 2B, it should have been 2B1.
It should be numerical too.
Done by someone else. But anyway, I'm not. Does your lordship? I'm sorry.
Vishwa Bharati came before UGC.
Much before. Vishwa Bharati University. Shanti Niketan, obviously,
Niketan was
much
there,
before. But
But
I just.
Vishwa Bharati University came sometime in 1951,
No, it was by an act of Indian Parliament.
Indian Parliament.
Yes, sir, your lordships are right. I stand corrected.
You said after UGC Act.
No, not. It was before that. I stand corrected. I have, my lord, that year also and the act also. Shanti Niketan, of course, my lord, was started by father of Rabindranath Tagore, but expanded and Lord, it reached its glory during the period of Rabindranath Tagore.
And we'll also sort of trace, I mean, those universities are not in question before us, so therefore we are not at all going to be commenting on them.
Yes.
But institutions which did get minority status, what was the course which they followed? What was the path which they followed? And you may want to make a distinction with AMU if you are that's your line of argument.
Lord, the question of minority status came only after the constitution came in.
Right.
Lord, I have not viewed that also.
All right, we'll see how that.
But Lord, we would be doing injustice to Aziz Basha unless we read it in the the context and the regime it was available. Because just, my Lord, this cannot be an argument, I am aware. But, my Lord, just out of curiosity, I just examined. Lord, Aziz Basha is 65 judgment, 1968 judgment, 1968 judgment. The honorable judges, this is not an argument, and please don't take this as an argument, must be around 20, my Lord, when 1920 Act was passed. Their age. They must be aware of this history, especially the author of the judgment. He was from Uttar Pradesh. Because this is the background. This was, my Lord, a very hotly debated issue in the country. This was a part of Khilafat movement. Ali brothers, my Lord, who separated and made Jamia Millia Islamia.
He was one of the few remaining ICS officers. He was
possibly the only Chief Justice without any legal background.
He was an ICS officer.
He was an ICS officer.
Mr. Dr. Lavan, right? Mr. Justice
Yes.
The advocates were in the majority and the ICS officers were in a minority. Very interesting about Golaknath. All of them were in the minority.
This is interesting. I did not know that. But possibly Justice Vanchu was the only Chief Justice who was ICS, who was not having a kind of formal legal background. Lord, please come to, my Lord, Roman 2F, page number 1. There is a chart, my Lord, we have prepared. Lord, 1813, I'll just quickly go through what is, my Lord, relevant for the purpose of completeness. But my Lord, we will have to keep this in mind while reading Aziz Basha, my Lord. It does not say what the other side apprehends. The Charter of 1813 of British Crown allocated funds for education in British India, leading to the establishment of institutions like Hindu College in Calcutta in 1817. Charter of 1813 read as under. My Lord, I may skip that, only, my Lord, see the highlighted part. Rest, my Lord, I have put it for completeness. Provision for schools, public lectures, or other literary institutions for the benefit of natives. We were natives, my Lord, we were subjects. To be regulated by the Governor General in Council, subject to control of the board, but appointment of two offices therein to the made by the local government. Then, my Lord, next date, 1817 and 1818. Hindu College established in Calcutta in 1817 and the Sri Rampur College is established in 1818 by William Carey, Joshua so-and-so, and William Ward. Then 1854, an education policy of British India came in the form of the Woods Dispatch of 1854, officially known as Dispatch of Indian Education. It was seminal educational policy document issued in 1854 by Sir Charles Wood, the President of the Board of Control for India. It marked a significant step in the development of modern education system in India. The dispatch advocated for the establishment of universities in major cities and improvements in schools. It specifically provided as under. Well, this dispatch is discussed during communications between those who were requesting for ALIGARH to be declared a university through an act of imperial legislature and, my lord, the British Crown, through, my lord, the officer of the British Crown. We now proceed to sketch out the general scheme of the measures which we propose to adopt. We have endeavored to avail ourselves of the knowledge which has been gained from the various experiments which have been made in different parts of India for the encouragement of education, and we hope by the more general adoption of those plans which have been carried into successful execution in particular districts, as well as by the introduction of other measures which appear to be wanting, to establish such a system as will prove generally applicable throughout India, and thus to impart to the educational efforts of our different presidencies a greater degree of uniformity and method than at present exist. Lord, para 24 only underline part may be read, my lord. And the I'm sorry, my lord, I'll just read the rapid spread of a liberal education amongst the natives of India. Since that time, the high attainment shown by the native candidates for government scholarships and by native students in private institutions, the success of medical colleges and the requirements of an increasing European and Anglo-Indian population have led us to the conclusion that the time has now arrived for the establishment of universities in India, which may encourage a regular and liberal course of education by conferring academical degrees as evidence of attainment in the different branches of art and science, and by adding marks of honor for those who may desire to complete for honorary distinction. The function of the universities will be to confer degrees upon such persons as, having been entered as candidates according to the rules which may be fixed in this respect, and having produced from any of the affiliated institutions, Lord, please mark this. Lord, this MAO remained an affiliated institution to the then Allahabad University, which was, my lord, created by an act of imperial legislature. I'll come to that. And today also it continues, my lord. In this respect, and having produced, which will be enumerated on the foundation of the universities, or be from time to time added to them by government, certificates of conduct of having perused a regular course of study for a given time, shall have also passed at the universities such examination as may be required of them. Your lordships can, my lord, consider skipping the rest. Then 28. The examination for degrees will not include any subjects connected with religious belief, and the affiliated institutions will be under the management of persons of every variety of religious persuasion. This was the policy document which mandated this. Either you accept it if you want an act, or you don't accept it, as it would come a lot later. As in England, various institutions in immediate connection with the Church of England, the Presbyterian College of so-and-so, 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 is empowered to receive certificates for degrees. So in India, institutions conducted by all denominations of Christians, Hindus, Mohammedans, Parsis, Sikhs, Buddhists, Jains, or any other religious persuasions may be affiliated to the universities if they are found to afford the requisite course of study and can be depended upon for the certificates of conduct which will be required. My lord, St. Stephen's continued as an institution with minority status, with predominant Christian attributes, affiliated with Delhi University. I'll come to that. Other branches of useful learning may suggest themselves to you, in which it might be advisable that lectures should be read and special degrees given, and it would greatly encourage the cultivation of vernacular languages of India, that professorships should be founded for those languages and perhaps also for Sanskrit, Arabic, and Persian. A knowledge of Sanskrit language, the root of the vernaculars of the greater part of India, is more especially necessary to those who are engaged in the work of composition in those languages, while Arabic, through Persian, is one of the component parts of Urdu language, which extends over so large a part of Hindustan and is, we are informed, capable of considerable development. The grammar of these languages and their application to the improvement of the spoken languages of the country are the points to which the attention of the professor should be mainly directed, and there will be an ample field for their labors, unconnected with any instruction in the tenets of Hindu or Mohammedan religions. We should refuse to sanction any such teaching as directly opposed to the principle of religious neutrality to which we have always adhered. Because Sanskrit, Persian, Urdu, they were linked to religion in during those times. So to an extent, my lord, even today. The candidates for university degree will, as we have already explained, be supplied by colleges affiliated to the universities. These will comprise all such institutions as are capable of supplying a sufficiently high order of instruction in the different branches of art and science in which university degrees will be accorded. The Hindu, Hooghly, Dhaka, Kishugar, and Berhamporo government Anglo-vernacular colleges and the Sanskrit college, the Mohammedan madrasas, and the medical college in Bengal, the Elphinstone Institution, the Pune College, the Grant Medical College in Bombay, the Delhi, Agra, Banaras, Bareilly, and Thompson colleges in northwestern provinces, seminaries such as the Oriental Seminary in Calcutta, which have been established by highly educated natives, a class of places of instruction which we are glad to learn is daily increasing in number and efficiency. Those which, like the Parental Academy, are conducted by East Indians, Bishop's College, the German Assemblies Institution, Dr. Duff's College, the Baptist College at Serampore, and other institutions under the superintendence of different religious bodies and missionary societies, will at once supply a considerable number of educational institutions worthy of being affiliated to the universities. So you had a choice of continuing as a denominational institution affiliated with some university which would be under an act of the imperial legislature. Towards then, 1856-57. Towards the end of 1856, the British government in India passed draft bills for the establishment of the first 3 universities in India, namely University of Calcutta, Bombay, and Madras. These acts were passed in the early 1857 by the Imperial Legislative Council, a representative body empowered by the British Parliament to make laws for British India, which continued till 1947. Lord, why I say British India, some of the part of present day India was not in British India. For example, Hyderabad was not. It was a charter of the Nizam, my lord, under which a college was established. Then 1860, Act number so-and-so of 1860 passed by the Imperial Legislative Council expanded the powers of the above referred 3 universities to grant degrees. Lord, I may not read, my lord, that part. It merely says that now you are entitled to confer degrees. Every university, whether recognized by the Imperial Parliament or not, were conferring degrees. Degrees had values, but they were not entitled to have employment in the British Crown services. Now, 1882. Punjab University was established by Punjab University Act 1882, again imperial legislature. Then Allahabad University was established by the Allahabad University Act 1887. Then 1902, the report of the Indian Universities Commission was published. The said report with regard to MAO specifically noted as under, because this, my lord, MAO was an institution, a Muslim institution functioning and, my lord, affiliated with Allahabad University. In connection with MAO College at ALIGARH, proposals have been put forward from time to time for the creation of a Mohammedan university. It does not appear that these proposals have received the support which would be necessary to give the scheme a practical character. And even its resources adequate to the formation of a complete university, where forthcoming, it is for the government to decide as to the expediency of creating a denominational university. There was no Article 30. There was no fundamental right. The government can decide whether there should be a denominational university or not. In the present circumstances of India, we hold that while no obstacle should be placed in the way of denominational colleges, it is important to maintain undenominational character of the universities. Taking clue from the Woods dispatch, the British policy continued. And that was the policy, in 1902. Then, Indian 1904, the Indian Universities Act was passed. This was an umbrella act which repealed other acts and brought within its purview above referred 5 universities, Calcutta, Bombay, Madras, Punjab, and Allahabad. It also reconstituted the governing bodies of the universities and gave statutory recognition to the syndicates. Now, my lord, comes the moment where this would be relevant for the historical perspective which I'll narrate. In 1915, 1st October 1915, Banaras Hindu University Act is passed by Imperial Legislative Council, leading to the establishment of the BHU. Now please see, my lord, para 4. The above history clearly depicts that British parliamentary policy was to confer the status of university only when the nature of the university is non-denominational, what we call secular, my lord, broadly in the present context. And second, provides for prominent governmental control. But please note, it's not governmental regulation, governmental control. This was an era in which establishment of any university which had advantages in the form of funds, value of degrees, I say value, not recognition, value of degrees, possibility of employment with imperial government by its alumni, etc., needed a legislative enactment by the British legislature fulfilling the above referred 2 criteria. In all cases where universities were established by way of an act of imperial legislature, it ensured both the above referred 2 criteria are met. The presence of both above criteria obviously changed and resulted in alteration of character of any institution, even if such institution was, before the enactment of imperial legislature making it an university, of a denominational or religious character. Such universities which were established by an act of imperial legislature were national, open, and secular centers of learning. The following is the list of universities established by imperial legislature before the constitution came into force. My lord, I have already mentioned Calcutta, Bombay, Madras, Punjab University, my lord, in Lahore, then University of Mysore, Banaras Hindu University, Patna University, ALIGARH Muslim University, University of Lucknow, University of Dhaka, Delhi University, Nagpur University, Andhra University, Agra University, now my lord known as Dr. Bhimrao Ambedkar University, Annamalai University. My lord, Annamalai University, please note here something would turn on that, my lord. There was a question that one who founding moment also has its value. No, there are 2 types of legislations. One, legislation which incorporates the university, and second, the legislation which, while incorporating the university, recognizing the founding fact also. In Annamalai, the founding fact is also recognized. I'll show that. That's a separate point. Then University of Sangyu, Rajputana, Guwahati University, University of Kashmir, Karnataka University, Maharaja Sayajirao University of Baroda, etc. My lord, I'm sorry, my lord, I stand corrected. My lord, page, item number 20, my lord, there is a mistake. It was established, my lord, in 50. That is in 46, but my lord, second amendment was passed in 50. Nothing turns on that, just a factual correction, my lord. Then Savitribai Phule University, formerly known as University of Pune, and Gujarat University, 1950. The universities established by Indian efforts without succumbing to British conditions and retaining its independence. Now, my lord, I have said that there were people who were ready to accept this non-denominational character and British governmental control. But that was an era of nationalism. That was an era of freedom struggle at its peak. So there were people that, no, we will have institutions from our own resources, will not have governmental control, we will not depend upon the British government's imperial legislation. Well, that I have seen. It is submitted that prior to the UGC, in absence of any prohibitive framework stopping someone from establishing universities without a legislative act, it was wholly permissible for any group of persons to establish an institution and label it a university or a Vidyapit or Jamia and claim to be the university. Now, my lord, this is prohibited. UGC Act prohibits use of word university, and you cannot be a university unless you are recognized under section 2F or section D. At this juncture, it is necessary to demarcate the distinction between a pre-constitution university established and recognized by the legislature as opposed to a pre-constitution university not recognized and not recognized by the British government. It is submitted that at the relevant time, it was wholly permissible for the MAO college to establish a university. There was nothing which prevented MAO from establish a complete Muslim university by the same name or any other name if it so wished, without any enactment, with the only drawback that such university would not have been recognized by the British government. It is relevant to note that there was no Article 30 and no concept of minority also. Pre-constitution, there was no concept of minority. There was a concept of Hindus, Muslims, Parsis, etc. There was no majority or minority during British regime. There is nothing that stopped the said institution from doing so, which would have maintained its independence and perhaps its minority character. A large number of pre-independence universities existed whose degrees were not recognized by the British government for appointment in services under the Crown, but nonetheless went on to become leading national institutions. They were getting jobs, my lord, in big industries in India. British Crown was not recognizing those degrees. A list of such pre-independence universities, please see. Lord, Osmania University. Nawab of Hyderabad, Nizam of Hyderabad established. Gujarat Vidyapit. My lord, this was, Vidyapit means university. The way Jamia means university, Vidyapit means university. This was established by Mahatma Gandhi in 1920 as a part of non-cooperation movement, that we will not go to the British Parliament, which, my lord, under now, after coming into force of UGC, Government of India, my lord, in 63, give them the status of deemed to be university under section 3 of the UGC Act. Then Bihar Vidyapit, again, my lord, Mahatma Gandhi established this university. Pasha says you had the option of doing this, but you surrendered everything. Now you cannot raise Article 30 issue. Lord, Bihar, then Kashi Vidyapit, now known as Mahatma Gandhi Kashi Vidyapit. Lord, again a product of non-cooperation movement, and your lordships would see at the right side, Uttar Pradesh State University Act was enacted, which recognized it as a university defined under the UGC Act. Then Jamia Millia Islamia. In case of MAO college, there were two groups completely hostile to each other on the question of further course of action. One group led by Mr. Shafi, can you remember this name? In the parliamentary debates of the British Parliament, Lord, he would open the debate on behalf of the British. Mr. Shafi wanted an act of British legislature surrendering the rights of functioning as denominational institution. And the second group, led by Ali brothers, who supported Khilafat movement when Ottoman Caliph was deposed by the British as an anti-Islam act of British. The second group, Khilafat movement, they played a major role because the Caliph was attacked by the British. It was more a pro-Caliph movement than freedom struggle movement. The second group strongly objected for any British enactment and insisted by any indigenous university retaining, insisted for, it should be, retaining denominational character. Upon passing of ALIGARH Muslim University Act 1920 on 14th of September 1920, there was an uproar amongst the opposite group led by Ali brothers who wanted to retain the minority character of MAO. This group therefore declared establishment of Jamia Millia Islamia from the campus of ALIGARH Muslim University itself on 29th of October 2020, just few days thereafter. This is, my lord, 14 September 2020, and after, my lord, that Jamia is, my lord, declared. Jamia means university.
Mr. Solicitor, only one thing. This is not really like, a contemporary date or something that we can take notice of. Can you give us the source from where this has been prepared, actually? So
yeah, it will come.
If it was footnoted or something, or if you have got some report or some historical document from which this is taken, because then while writing the judgment, we'll have to study all those reports, etc.
It was there already on record when we filed the writ, my lord, our documents first.
Alright.
And, my lord, we will give the reference, my lord, a little later. Now kindly see, my lord.
Because, this is...
Your lordships are right, my lord. This is a court of record, my lord. Retain its character.
Look at basically what was the status. I mean, we want to read through with you on your submission, but later on you can, when you are developing your submissions,
Yes.
what was the status of AMU under the 1920 legislation? And we can look at what was the status as on the eve of the adoption of the Constitution. So what happened between 1920 and 25th of January 1950? Because after 26th of January 1950, there cannot be a change in status. Because if it is a minority institution as on 25th January 1950, then the right becomes absolute on the birth of the Constitution.
Correct.
So we will have to then see, and as Brother Suryakant was just saying a moment ago, 50 to 56 is a further window because UGC Act comes in 1956. But the first step is for us to see what happened in 1920, what was happening between 1920 and 1950.
Yes.
Right.
My immediate answer is, and I'll develop that, between 1920 and the Constitution coming into force, there is no change in the Act. 1920 remains as it is. The first amendment comes in 1951.
And second, is the 1920 legislation also consistent with recognizing the pre-existing history of AMU, namely the MAO college, that it was predominantly founded by minority? Or does the Act itself, the 1920 Act, result in the abrogation of any claim to minority status?
Once, that's why,
We will not call it minority status, because minority status has a certain connotation under the Constitution.
Yes.
Does the 1920, if I'll change my language, does the 1920 Act have the consequence of abrogating its status as a denominational institution?
Exactly,
Governed by a religious minority.
Absolutely. And your lordships are right, absolutely right. That I will have
You
to
could
show,
not
and I
do
will.
that post-constitution because you can't ask for a surrender of constitutional rights or fundamental.
Cannot be, but I can't
But
argue.
prior to the constitution, the regime was entirely different.
Yes, yes. My lord, that's my lord, why I am giving this history. My lord, the purpose of giving this history is this. Lord, my respectful reading of Aziz Basha is that Aziz Basha's ratio is that you had three options. A, remain a denominational institute, the way a part of you, Jamia Millia Islamia remain, or other institution remain. Denominational or other unrecognized institution. Unrecognized in the sense that without any...
As a matter of just curiosity, what was the path which then Jamia followed?
Jamia remained an institution, remained a university, and thereafter, my lord, after this National Commission Act came in 2004, they applied for being declared a minority institution, and it was so declared.
That matter is still pending.
Still pending, my lord. Therefore, I'm not going beyond.
What you're arguing may have impact there also.
My lord,
may have impact.
My lord, I'm consciously, my lord, arguing only those parts which may not affect me here, but either way. Your lordships are right. My lords are absolutely right.
And I was a member of the bench which admitted the petition. Let me tell you, the government over there had also changed their stand on Jamia Millia Islamia, whether it is a minority institution or not.
Possible. But I'm not, Lord, I didn't appear, but your lordships are right, my lord. Possible. There is
Your distinction with Jamia for the purpose of this case may ultimately affect you in the Jamia case.
No. I'll be, my lord, conscious, my lord. Your lordships can write, my lord, or whatever.
Right. We will not trench into an area which is a subject matter
of another litigation because Jamia is not here, my lord, otherwise also.
Right.
But, my lord, the point I'm making is Jamia is just an, my lord, illustration. There were several institutions.
So according to you, Jamia was born out of the desire to preserve the denominational status of a university.
Which was surrendered
in the case of MA.
Case of ALIGARH. That I will show and with pagination.
Let's go ahead.
But my lord, I'm really tempted, my lord, to show to your lordships, my lord, the pre-constitution. I'm sorry. Lord, Ali Brothers writes a letter to Raja of Mahmudabad, my lord, who was on the other side, my lord, in favor of ALIGARH University being established. That these people are sent in the service of God, not service of British Crown. And therefore, what you have done is disastrous, etc. But leave it at that. There were institutions during that pre-independence, independence struggle time, like ultimately became Vishwa Bharati, which had reputation, which used to grant degrees. Degrees were recognized, except in British Crown services. Please see, that list. I am not reading the entire list. At page 11, Delhi College. No law of British Parliament. It was affiliated with University of Delhi. I just give some examples without going into Scottish Church College, Kolkata, item number 6. Presently a minority college affiliated to the University of Calcutta. It continued as an institution, continued as a minority. St. Stephen's is a pre-constitution institution. It continued continued to be affiliated with Delhi University. Please come to page 13, Roorkee College of Engineering, page 13. 1847, Government of Northwestern Province established College of Engineering at Roorkee in 1847. In 1853, college was renamed as Thomson College of Civil Engineering, which got affiliated to Calcutta University in the year 1864 and later to Allahabad University in 1894. The college was incorporated into Roorkee University with a Roorkee University Act 1948 passed by provincial legislature. In the year 2002, the university was incorporated as Indian Institute of Technology, Roorkee, and was declared as institution of national importance. But during pre-constitution, it chose to continue as an institution without any imperial legislation backing it. Then, then St. Stephen's College, item number 16. Founded in 1881 by Cambridge Mission in Delhi in conjunction with, your lordships have para 16, in conjunction with Society of Propagation for Gospel. The college became one of the 3 original constituent colleges of University of Delhi when it was established in 1922. Delhi University was established thereafter. The college existed. Thereafter, my lord, please see, 25, page 16, very eminent college, but now a university, Gurukul Kangri, I think somewhere in Haryana, Gurukul Kangri now is a deemed university, was founded on March 4, 1902 by Swami Shraddhanandji, became the deemed university after enactment of UGC Act in the year 1962. Then, my lords, may kindly skip and come to 30. Dakshin Bharatiya Hindi Prachar Samiti. This is a linguistic minority institution in South India. In Karnataka, this is a leading institute. Dakshin Bharatiya Hindi Prachar Sabha was established by Mahatma Gandhi with the sole aim of propagating Hindi in southern states. The institute got the status of being an institute of national importance in 1964 by Dakshin Bharat Hindi Prachar Sabha Act 1964. The act came into force thereafter when Indian Parliament took it over. 33, Vishwa Bharati. Ravindranath, we say Tagore, it's also called Thakur, established an institution known as Vishwa Bharati at Shantiniketan, later established as a university and recognized as an institute of national importance with a Vishwa Bharati Act 1951. Lord, your lordships, I'll take your lordships through that. Lord, entry 63, that the central government has the power of declaring some of the institutions as institutions of all IIMs, IITs, etc. My lord, Vishwa Bharati is one of those, my lord. So, my lord, there were, my lord, I have given the illustrations. I am not reading, my lord, all the illustrations.
Where have you drawn this from, Mr.
Lord, this is from the public domain, my lord, from
But from individual colleges' websites, or is there some report from which you have got this?
From the websites, individual colleges' websites. But the rest of them, my lord, I have given, my lord, the act, pagination, where would you, your lordships find, my lord, in the document compilation, etc., from here onwards. But kindly now come to page 22, my lord, para 11. And here your lordships would find, my lord, the pagination and reference, everything. The birth of Jamia and AMU, the backdrop of ALIGARH.
Kalakshetra at state number 44.
I'm sorry, my lord.
State number 44, Kalakshetra is a very famous institution.
Very, very, yes, my lord. But I was, my lord.
Rukmani Devi are there in 1936.
Yes, my lord. My lord, Rukmani Devi Arundale established this. No, I didn't want to, each, my lord, for a 43, Indian Statistical Institute. It's now an institution of national importance. Lord, there are several which eventually, Lord, went on to become institution of nature. Banaras Engineering College, Lord, 31.
Now 22 you want us to go to, right?
30, yes, page 22. Well, there are several which chose, and the choice which was available with MAO, that is what Bhasha says. Bhasha doesn't say that because you have become a university, now you cannot have a minority status. No.
What are the indicia? Later on we'll again look at it. What are the indicia to indicate that when it was conferred with a university status, that it surrendered its minority status?
Yes.
The mere fact that it is converted, that it is given university status does not amount to a surrender of its minority status.
No.
Or denominational status prior to independence. We'll have to independently see whether by the 1920 Act, the denominational character of AMU was lost. You have given us that little thing about, the Khilafat movement and everything.
I have given three compartments. I have given the correspondence which is already on record to show that there was a correspondence between Britain and MAO College, that you will have to do this if you want an act to be passed. Second, the debates in the Imperial Parliament, where Mr. Safi introduces the bill and keeps on surrendering, my lord, the denominational character. And third is the Act itself. The Act as it stood in 1920.
So your argument is it's not the enactment itself, but prior to the enactment.
Exactly. And his lordship says that it is the fact that you have surrendered and Act came into effect. Now you cannot claim minority status. And I'll show that finding. Lord, Bhasha was very cursorily read. Some patches here, some patches there. Lord, I want your lordships to read Bhasha, Lord, the way I would wish your lordships to examine. I'll
return after lunch.
Yes.